Parthasarathy, an advocate on record in Supreme Court of India, and he has already done one session with us at the time when we were at the infancy stages of thought processes as to how we should go with the process of beyond Law CLC. And today, after around a year, we have connected with Mr. Parthasarathy on a topic which we are a lot of, as a student of law, lawyers and judicial officers and judges, keep on discussing regarding the new Tribunals Reform Ordinance 2021, implications of IPR, more specific. Though this particular ordinance speaks of various acts which have come into being, but this ordinance, we are only taking on the intellectual properties, primarily on that focus. Without taking much time, I would request Mr. Parthasarathy to take things forward. And it's always a pleasure connecting him outside this platform, but on a knowledge sharing platform, which is at large for the larger public at interest. It's a pleasure connecting back to him. Over to you, sir.
Good evening to all of you. As Vikas pointed out, I think I have to thank all of you first for joining on a Sunday evening at 6 o'clock. Despite maybe we are still having a second round of COVID and all that, but still it is Sunday and evening at 6 o'clock. So I'm extremely grateful for all of you for joining. And of course, I'm always grateful to Beyond Law CLC and Vikas personally for inviting me again to share my thoughts on this particular topic today, which is the Tribunal Reforms Ordinance. With this a short introduction, I'll just quickly take you into my presentation, which is a very short presentation of 13 slides. And you will see, of course, I'm looking more to a discussion and viewpoints from people who are here. I know many of them are on the IPR practicing side as well. So I'm just trying to get their viewpoint as well. So with this introduction, I'll quickly start sharing my screen. I think all of you are able to see the slides now. Okay, right, thank you. As Vikas said, and the topic for the day is tribunal reforms, actually rationalization and the conditions of service ordinance 2021. And as Vikas pointed out, being a practitioner on the tax side and the IPR side, I said this has more implications on the IPR side. So I will talk or restrict myself to the IPR angle because the others I generally don't deal with them. So I don't want to get into a subject where I'm not sure of myself. So I'm restricting myself to implications of this reforms for IPR. Now, probably we can conclude this seminar in one sentence by simply saying that as per this ordinance, the Intellectual Property Appellate Board, which is the tribunal constituted to hear appeals from trademark, geographical identifications, patents, and copyright, plant variety protection, that stands abolished. And all that has happened is it has all gone back to the jurisdiction of the respective high courts. So the ordinance seeks to abolish the Intellectual Property Appellate Board and substitute in its place either the commercial court in the case of copyright or to the high courts in the case of other intellectual property rights. So if that is all that has happened, what is great? In any case, you got one forum instead of another forum. But the why we have taken this particular topic is just to see what is the rationale which the government has given in order to abolish the Intellectual Property Appellate Board and transfer the jurisdiction to High Court. In any case, prior to 2003, when trademark came under IPAB, it was with the High Court. Before 2007, when patents appeals came under IPAB, it was with the High Court. Copyright till 2017 was not with the Intellectual Property Appellate Board, and the Plant Variety Protection Act, etc. We had one member technical, but hardly really any matters which have really come up for disposal before the IPAB, which is also now transferred to the High Court. So generally you can say whatever was already with the High Court got transferred to a tribunal, and now it is getting again transferred back to the High Court. So to that extent, yes, we are going back to 2003 or 2007 as the case may be. But is the reason behind this ordinance and earlier the bill, is it really based on proper data, or could we have something done to better utilize the intellectual property appellate board rather than burden the matters to the High Court? That's the point where I wanted to share my thoughts with all of you. Now, very quickly, just 1 second. Yeah, as I think most of you know, a bill was introduced on the same subject in the Lok Sabha on the 13th of February 2021. And of course, the bill could not be taken up and passed during the budget session. And now the ordinance has been issued, and it is effective from 4th of April 21, that is 2 Sundays before today. And the rationale which is given in the bill is, it says an analysis of the last 3 years data shows that justice delivery in the case of these various acts and the tribunals which it seeks to abolish has not been faster. It has also ensured that there is a high cost to the exchequer. It had added another layer to the litigation, and it has also addressed the issues of there is a shortage of staff and there is a shortage of infrastructure whenever these tribunals are created. So considering these various difficulties, the bill was introduced, say there are certain tribunals. Earlier also in 2015 onwards it was undertaken, and in 2017 the number of tribunals was, if I remember right, reduced from 26 to 19. And as a further process of rationalization, this bill has been introduced, but now that has been converted into an ordinance. So the analysis of the last 3 year data and the reasons given for rationale for the bill, do they stand at the test or scrutiny is what I'm trying to say. And please be clear, it is my own personal view, and it is based on my own analysis of the various data and the information. So that is one caveat which I wanted to put. You can have different views, because I myself know as practitioners intellectual property, we have even represented to the government at some points of time to point out that the IPAB has not been functional because of non-availability of either the chairperson or the technical member, and without any other alternate remedy, it may be best not to have the IPAB. Therefore, it is not that we are saying IPAB has not been effective. It has not been effectively made functional by appointment of the technical person and as also the chairperson at appropriate points of time is the point I wanted to know. That's the reason why I've said, is it a case of throwing the baby along with the bathwater? It is my view that it is actually throwing the baby along with the bathwater, is what I wanted to canvass before you. Now, as you all know, the ordinance seeks to amend some 10 acts, but what we are concerned is not the Cinematographic Act or the Customs Act or the Airports Authority India Act or the National Highway Act or the Finance Act 2017, which talks about various conditions of service and manner of recruitment, etc., which itself is going to be another matter of litigation before the Supreme Court, because despite Supreme Court's clear directions to the contrary in 2 or 3 judgments, including the Roger Matthew case and thereafter in the Madras Tax Bar Association case, more or less the same set of things have come in the ordinance also amending the Finance Act 2017. We are not getting into that. What we are really looking at is the Copyrights Act 1957, the Trademarks Act 1999, Patents Act 1970, the Geographical Indication of Goods Act of 1999, and the Plant Variety Protection and Farmers' Rights Act of 2001. These 5 acts together is what I call as the intellectual property rights, and I am talking in connection with these 5 IPRs. So this is what we are talking about. Now, if you take the Trademark Act 1999, it was only in 2003 that appeals from the orders of the registrar, etc., or from various other aspects were given to Intellectual Property Appellate Board. Till then, it was with the High Court, as I already pointed out. Similarly, Patents Act 1970, 2007 was when patents work was introduced to IPAB, even though IPAB was in existence, but patents was not extended on appeal to IPAB, and till then also it was only with the High Court. Similarly, Geographical Indication Act 1999, Plant Variety Protection, as I said, They wanted a separate tribunal. That is what the Act says. But later on, they said the IPAB, constituted in the Trademarks Act, will also be the tribunal for the PPV FRA Act, with the one modification that the technical member will be a member who has got expertise in plant variety protection and other aspects. So that is what the technical member qualification, like it was different for copyright, trademark, patents, it was different for the Plant Variety Protection Act. So with that modification, instead of creating a separate tribunal, they entrusted that also to the Intellectual Property Appellate Board. Similarly, in Copyrights Act, actually only in 2017 Finance Act, certain appeals and other things were made appealable to the Intellectual Property Appellate Board. Till then, Copyright Act was also not being dealt with by the Intellectual Property Appellate Board. So you have a situation of at different points of time, the work was taken out from the High Court and entrusted to the Intellectual Property Appellate Board. And now we are putting the clock back and going back to the same position as we were earlier. Now, one important thing, as you all know, is we are all talking about various appeals which are arising from the various orders of the officers under these acts and certain other orders which are appealable. We are not talking about infringement. Infringement action, as you all know, is always before the district court. And of course, there is a counterclaim, etc. It will be before the High Court. And also it can be directly before the High Court, depending upon the original jurisdiction of the High Court and also the pecuniary limits as under the Commercial Courts Act of 2015. So infringement and the corresponding counterclaim were always with the High Court and will continue to be there. What we are now only talking about is appeals from various orders passed by the officers under various sections of these acts, which was taken away from High Court and given to IPAB. Now going back is what we are going to talk about. Now, very quickly, even though 2003 was the year trademark work was actually entrusted to the IPAB, I've just tried to analyze how the situation is going in the last 5 years. If you see, the number of filings in trademark applications has gone up from 210,000 in 2014-15 to 323,000 in 18-19. So we are talking about more than a 50% increase. We are talking about in the trademark applications filed. And if you look at the examination is also increasing exponentially. From 1,68,000, it has become 3,37,000, which means almost 100% increase in the number of applications examined had happened over a period of 5 years. And if you see in 2016-17, it reached a peak of 5,32,000 applications had been examined in 2016-17. So if filings have increased by 50%, examination is speeded up and had become almost like 100% increase. And the number of trademark registrations granted, if you look at it, has also skyrocketed from 42,000 to 3,16,000 in 18-19. And if you see 16-17, 17-18 and 18-19, it is 2,50,000, 3,00,000 and 3,00,000. So it's a significant grants and registration of trademarks have happened during the last 3 years for which the data is available. Now, while the registration is like this, if you look at the disposal is from 83,000 to 5,19,000, or we are talking about almost like a 5-fold or a 6-fold increase from 2014-15 to 18-19. The disposals have gone to 5,19,000. In 17-18 is 5,55,000. Now, what do you mean by disposals is you have the registrations, you have the rejections, you have the abandonments, and you also have the withdrawals. So all these 4 put together is what we have as 5,19,000. So what was registered was 3,16,000. So you have something like 2,00,000 and odd coming as part of either rejected or withdrawn or abandoned. So we are seeing a significant difference between the disposal and the registration, which definitely points out to some amount of rejections also increasing. And each rejection increase holds a chance of it going on an appeal, either to the earlier tribunal, now it will go to the High Court. And that is where the workload of the High Court is going to increase, and whether the High Court will be able to handle it, or with some modification, the Intellectual Property Appellate Board could have done better. That's the point which I was trying to point out. So you see that the general trend is filings, examination, registration, disposal, everything has been significantly increasing during the last 5 years. And Of course, all of you know India is an important market. Nobody can ignore. So people are definitely coming to India and getting their marks registered, and they are also protecting their rights in India. Now, as I said, the difference between the registration and disposal is because of three reasons. Now, if you see that trademark rejection data, this I was able to get it from WIPO as per the trademark office procedural data. One of my colleagues, Vindhya, who is here, she was instrumental in giving me this information. I thank her also formally. What was the rejection of 13,875 in 2017? Increased to 1,01,000 in 18, and it is 78,839 in 2019. So you are again talking about a six-fold or a eight-fold increase in rejections between 2017 and 18 and 19. Therefore, each one of these rejections is a potential candidate for appeal. Suppose you say only 10% of it goes, or let's say 20% of it goes, we are talking about 10,000 appeals or 8,000 appeals from 18-19 going into the stream, whether the appellate tribunal or to the High Court. For the time being, I'm keeping it like that. So you are looking at a very big number of filings due to rejections being taken up before the appellate forum. So it's a very important that the appellate remedy is very effective and efficacious. If it is not, and all these intellectual property rights are very, very important and valuable rights, the earlier you get, the earlier you are able to enforce and you are able to protect yourself. And these are also areas where the international community is watching us. There are comments from various countries regarding the function of the Intellectual Property Appellate Board, because if the appellate forum was not there, then you have the problem that your application, which is rejected, is languishing in appeal. And by the time it is granted, in many cases, the last 3-4 months when IPAB is functional in October, November, December, cases where 18 years, 17 years of the 20-year lifetime had already expired, and you are trying to get the patent granted. So appeal is a very, very important and has to be a very efficacious remedy in intellectual property if we have to enforce our rights. So that is where I think we'll have to see whether it is IPAB or the High Court, how to make it very effective and very timely. That I think is very, very important. But the number of cases are significantly increasing in trademarks. Now look at this. Before 2007, in patents, everything was going to the High Court. Now I had to be able to collect this data for 2002-03. You look at the number of legal proceedings that are pending the High Court. We are talking about some 26, 22 writ petitions, 6 revocations, 4 miscellaneous petitions, etc. So the situation prevailing before 2007, as far as the patent was concerned, was totally a different picture as compared to what we have today. After 2005, when our patent system was brought in line with the TRIPS agreement, we have an explosion of number of patent applications being filed in India and prosecuted and also enforced by various stakeholders. Now that has significantly increased. Therefore, the position which was in High Court, this data cannot probably be the basis to determine if it goes to the High Court. There are hardly any appeals which the High Court probably can take care of, and there is no need probably for a separate tribunal, etc. Because this was the position either for trademark or for the patents. What was prevailing before the IPAB was very, very insignificant as a matter of litigation. Now, looking at that figure, what was pending before the High Court, now look at what is the latest trend in patent applications for the last 5 years. So you are seeing the applications filed is between 42,000 to 50,000. So we are talking about an average of 45,000-50,000 applications are being filed every year in India, patent applications. Now, examination were very slow. There was a lot of delay in issuing the examination reports and granting the patents. And that has speeded up now from 22,000 to 85,000, again, a 4-fold increase, 3-fold in 17-18. Number of examiners recruited, trained, and then they are issuing the examination reports and then either granting or rejecting the applications, etc. So that also has increased. Now, grant also from almost 6,000 to 15,000, 2.5 times the grant has also increased. And the disposal has also increased from 14,000 to 50,884, which is again more than 3.5 times increase between 14-15 and 18-19. Here again, as you know, disposal is Granted 15,000, which means 35,000 is something else. It is part, some of rejected, some of them are withdrawn, some of the patent applications are abandoned. Whatever is withdrawn or abandoned, we are not concerned. We are only really concerned with rejections. Now, we are able to get some detail on this also. The rejections in 2016 were 2,144, increased to 3,200, almost same 2,925, but in 2019 it has become 5,100. So there is again significant increase in the number of rejections. Here again, while 100% of the rejections may not get challenged, but I would not be surprised if at least 25 or 30% of them challenged, because some of them may not be challenged for the reason already 15 or 16 years of the life of the patent might have expired, and the client may feel there's no point in getting the patent now and spending money, so they may not pursue. But at least 25%, because now the examination is passed and you still have 8 or 10 years after the grant, your life of the patent is there. If there is a rejection, they are bound to follow the appellate procedure. So you are again talking about 5,000, and I think 2020 and further, I think lot of examination reports, lot of hearings, and lot of grants and disposals are taking place. Therefore, the number of filings are challenged to the orders of the controllers rejecting the patent is also significant before the appellate body. Now, we have some statistics on what are the IPAB filings, but somehow I was not very sure. This is, of course, the data is authentic, but somewhere there are some differences. But more important is, this is talking about oppositions and rectifications filed, but whether rejections challenged are also contained in that, or there is a separate one, we are not able to get some of the data. But you can still see the trademark filings, or we are talking about from 17,000 onwards, it has come to almost like 51, 52,000, 18, 19. So it has also increased more than threefold from 2003-4 to currently to 18, 19, it is increased with threefold. Similarly, hearings of opposition, etc., so hardly from 3,500 to 50,000 is also increased. But of course, because of the backlog, you still have a lot more of things to be done. On the patent side also, from what was 98 when it was first brought before IPAB, it has become like 454. This pre-grant and post-grant oppositions filed. I'm not very sure what are the nomenclature used, because pre-grant and post-grant before the patent office, if they are rejected or granted, whether they are challenged, etc., that's what is contained. And whether simple patent rejections are also contained, I have doubt, because a number of patents rejected is significant, and this may not reflect the appeals against the patent rejections also, but we will try to get some of those data as well. But suffice it to say that the filings and hearings before the Intellectual Property Appellate Board have also been significantly increasing from the first year of 2003-4 for trademark and 7-8 for patents, the current year. So we have a situation of increase in trademark filings, increase in patent filings, increase in examination and grant and disposal, and correspondingly increasing in the filings before the IPAB and also hearings. So it shows a picture where probably IPAB was also having a lot of appeals before it, and was also hearing many of them and disposing them off. And this is the figure as on 13th February 2021 of the disposal of cases at the IPAB at a glance. But more important, this is an information which many of us from the IP practitioners have made a representation to the government, highlighting what are the various issues which made the IPAB non-functional, and how those could be rectified, rather than probably winding it up and then handing it over to the High Court. That's the representation, in that we have included this type of information which you have been able to collect from the Intellectual Property Appellate Board. So this is broadly, you can see that whenever you can see the IPAB had been functional in certain years, you'll find there are significant disposals on the trademark side as also on the patent side. Now, when you come to High Court versus IPAB, now because of the abolition of the IPAB, now patent, because you have 4 patent offices in Delhi, Chennai, Mumbai, and Calcutta, any rejections or any challenges passed by controllers in those offices or applications filed in those offices will probably go to the respective 4 high courts. As far as trademark is concerned, of course, you have the same 4, plus you also have Ahmedabad, you have a trademark office, so you have Gujarat High Court also getting into that. Now, you compare this, which means you are talking about at least 4 single judges in the 4 high courts hearing patent matters and 5 single judges in 5 high courts hearing any appeals from the trademark matters. As compared to that, in the Intellectual Property Appellate Board, we have 1 chairperson, we have 1 trademark technical member and 1 patent technical member. You don't have a PP technical member and all that. There was for a short period 1 person there. He then became the vice chancellor of the Ranchi Agricultural University and he had also gone away. Now, this is also not that at all times the chairperson, the technical member on technical patent were always present, because if they were always present, then again the situation could be totally different. Maybe the disposals, etc., could have been there. But we have also given statistics saying how for almost like more than 1,000 days, etc., the IPAB could not be functional because either the chairperson was vacant or the post of the technical member was vacant, and therefore the IPAB, the Intellectual Property Appellate Board, could not properly function properly. So this is something which I think we'll have to keep in mind when we. Now I want to share with you my experience with other tribunals as a tax practitioner. Apart from IPAB, I have a lot of exposure with the CSTAT, before which I have been the Customs, Excise, Service Tax Appellate Tribunal, in which I have been arguing from 1996 onwards. Now you have an ITAT, again, so it's a very big tribunal, oldest tribunal. After that only we have CSTAT, etc., which came into existence in around 1982. Now you have, to start with, if it is Delhi headquarters, you always have a bench in Chennai, you have it a few benches in Bombay, you have a few benches in Calcutta, you have it in Hyderabad, Bangalore, you have it in Allahabad, you have it in Chandigarh, etc. You have to slowly, as the work expanded. Of course, tax litigation is also big. I'm not denying that. But the important point is it had always a combination of judicial member and the technical member. While the president is always a retired judge from a high court, but you have a number of advocates, more than 10 years experience, coming and joining as member judicial. And you have commissioners of central excise, service tax, or customs acting after 3 years experience as commissioner, joining as member technical. And every division bench is always a member of member judicial and a member technical. That's how it was. Same thing in ITAT, you got member judicial and you called an accountant member. The technical member is called as the accountant member. So you have a division bench, and all of them, because of the fact that you are talking about always you have 8 to 10 judicial members across the country, and you have always 8 to 10 technical members. Even if the sanction capacity is 15 and you got 10, you can still assemble 10 benches. Those 10 benches could hear the matters and dispose the matters, etc. Therefore, there was a lot of disposals by these tribunals, both the CSTAT and ITAT. So a combination of a number of judicial members and number of technical members enabled to assemble a bench of judicial member and technical member. Today, for example, this week and last week, we don't have a technical member in Chennai CSTAT for the last 2 years. But we have, because of the virtual hearing, we have the technical member sitting in Hyderabad and the judicial member sitting in Chennai hearing the tax matters. We are able to still proceed with that. Therefore, the most important thing is the number of the judicial and number of technical members available makes it, even if it is 20 members each, but you have only 14 of them, you still can function and you can still give a lot of disposals. And therefore, the visibility that the tribunals are effective was there. But when you come to IPAB, we are talking about 1 chairperson, 1 technical member for patent and 1 technical member for trademark. I think it's grossly inadequate as compared. Now, today, what you are going to do is you are going, definitely all these matters will be before 1 single judge in 4 high courts, or in trademark, it can be before 5 high courts. It is equivalent to having 5 members. But in IPAB, somehow it is always restricted to 1 technical member and 1 chairperson is there. According to me, it's my personal opinion, there should have been at least half a dozen judicial members and half a dozen technical members. And in patents, you require those technical members because you have a variety of technology. Even if I say I'm an expert in chemistry, Even in chemistry, there are any number of subjects where I may not know, but at least I will be able to understand what that aspect is. So you have chemistry, you have life sciences, you have biotechnology, you have electrical, electronic, telecommunication, mechanical, so many branches of engineering, and you are talking about one technical member. The first technical member was electronics. The second technical member was from chemistry. Now, the current technical member who before abolition, he had experience in other aspects. But they all have one subject. Whereas if we had half a dozen technical members and half a dozen judicial members, I think the tribunal would have been very, very effective. And more important, even that one technical member and judicial member were not always together. If you had half a dozen, even if two retired and it took time to appoint those two, at least 4 benches could have been functional. The disposal would still have been there, and it would have been possible to conclude that the tribunal was effective given its staff strength. That is how I think it has to be looked at it. Whatever the importance which was given to the tax tribunals like CSTAT, ITAT in terms of judicial and technical members, I think that type of importance and adequate number was not given in the case of IPAB. This is my personal view. Now, when this ordinance came, there was an article by a former judge of the Madras High Court, Justice Prabha Sridevan, who was the IPAB chairperson, who agreed with the view that IPAB should be abolished. And after that, a contra was written by Mr. Chaswal, who was a former technical member of Trademark. He pointed out as to why the IPAB was effective. Now, my view is whether it is effective or not effective is dependent on how the tribunal was manned and functioned. The most important thing was to have the members present in order for them to constitute benches and hear the matters. The problem was because the chairperson is always from the High Court, a retired judge, etc. Most of the time, 62 they retire and 65 they retire in 3 years. They never get 3 years because they get appointed after they retire from the High Court, and then they are again preparing. So 2.5 years is what there. In that period, if there is no technical member, I think practically they're sitting idle. They are not able to do anything. So that was the problem. Having both the technical and judicial member, even if it is 1 or 2, if they are consistently there for all the 365 days of the year, I think the disposal would have been different. And the analysis which we have done now to say maybe the delivery system was not good, etc., have all to be looked at as to how the members were appointed and how the benches functioned. I think that was the major problem which was not there. Therefore, I would say it is definitely to do with one, infrastructure for the Intellectual Property Appellate Board, definitely. The second is inadequate numbers of judicial and technical members and recruitment of these people, and at least even whatever sanction strength was there, not operating them fully all 365 days, year after year. I think those are the contributory factors, according to me, which led to probably a view being taken that the IPAB was probably not very effective. So that if I want to share one very interesting data with you. Now, in the European Patent Office, as many of the practitioners know, there is an enlarged Board of Appeals. Now, as of 2021, there are 28 boards of appeal, and they are called as 3.201 to 8. There are 8 boards in that, 3.3 10 boards, 3.4 3 boards, and 3.5 7 boards. So you are talking about 28 boards of appeal. And when I talk about boards of appeal, each board of the 28 has a separate chairperson, has separate technically qualified members and separate legally qualified members. They call them a TM, which is technically qualified members, and LM, which is legally qualified members. And what is the basis of 28 is they have allocated cases to each board on the basis of international patent classification. So if you say computer science, it has a particular classification, then they say it will go to board 3.4.02. And if you go to 3.4.02, you will find that there is one chairperson, there are 6 technically qualified members, there are 4 legally qualified members, etc. For each one of them, the composition is given. I've just summarized them to show. Therefore, there are 28 chairpersons, there are 138 technically qualified members, and 101 legally qualified members. I'm not saying, of course, as a result that we should copy this. All that I'm trying to point out is technology in the patent side is extremely vast. Europe, of course, has 27 different countries, and the European Patent Office examines for all of them, and grants, rejects, etc. All of them have to be definitely dealt with in appeal. So you have a number of votes. But when you have so much of 28 chairpersons, 138 technically qualified, and 101 legally qualified members, is it not possible, at least in India, to have half a dozen judicial members, half a dozen technical members, and a chairperson, in which case we may be able to constitute at any given point of time 5 to 6 division benches, in which case I think the disposals would have been really fast. And speed is very, very important, especially in the case of rejections of a patent, trademarks, etc. Because in patents, as many of you know, the 20 years lifetime not starts from the date of grant. It is from the date of filing. A specific particular date is there. So most of the time, by the time it gets granted, it's already 10 years. If it is an appeal, and in appeal it is not decided, but it goes back, order is set aside and goes back to the controller again, you are losing time. Therefore, time is really the essence in the cases of rejection, or even in the grant of revocations which are filed because a patent ought not have been granted, therefore it comes for a revocation before the Intellectual Property Appellate Board. Time is of the essence. And when you have time is of the essence, I think one bench alone for patent, or one bench for trademark, or one bench for copyright, or even 2 benches, I think will be totally grossly inadequate. And that, according to me, is a reason as to why it might have been felt that IPAB is probably not performed as was expected, and therefore we are going back to the High Court. Now, I have absolutely no problem about the High Court, but I also have experience where, because the IPAB was not functional, we have challenged certain orders of the controller before various courts. And the courts telling me, Partha, these are all highly technical subjects. And in a writ petition, you are coming and asking me to examine. And I am asking them only purely legally, saying how the order is incorrect. But even that, there was reluctance, because they say it's technical subject matters, how do we enter into, etc. But still, because the IPAB was non-functional, I think based on certain legal lacuna, the orders were set aside and was sent back. But it was again going back only. Now, while trademark, I think it may be much easier for a judge. But in a patent, if there is a rejection of a computer-related invention under Section 3K of the Patents Act, and I am saying how it is not a computer program per se, and therefore the controller has committed a mistake, the single judge has to hear and has to grant the patent, or grant it with modifications, whatever there, or again, if it goes back to the controller, then of course, again, very tight timelines for them set. I think these are very, very important. So we do not know how it is going to develop, because while the high courts will definitely be functional, unlike the IPAB where without member nothing can come, but most of the high courts also have vacancies ranging from 20 to 25%. Therefore, we still are going to face a lot of difficulties in the high courts. And many times, people who have practiced in many courts will know that you get a date almost like once in 4 to 6 months. Once your date is missed for some reason, somebody wants a time, it goes another 4 months or 6 months. So in a year, you are able to get 2 or 3. So sometimes that type loss of 2 or adjournments will ensure that your case does not come up for over a year. So these are some of the difficulties which we are going to face as practitioners going forward in the high courts, especially on the technical side of the patent rejections, etc. So I think as practitioners, we have to live with it, and we have to develop our ways of ensuring that we get adequate relief at the high court level. But the sum and substance of my conclusion, as I said, purely thing is IPAB could have been made more effective by having higher number of technical members and judicial members, and making them continuously, some minimum 3 to 4 benches should have been functional at any given point of time. I think we would have had a much better justice delivery system than abolishing the IPAB and going into the High Court. I think that's all that I wanted to convey to you. Thank you all very much. I put questions, actually questions not your opinion. I think any other, a lot of practitioners here, please, you can share your view on what I have said. Again, it based on whatever data I have come and analyzed, you may have a different experience also. You are welcome to share your experience with me, but it looks like the representations we have made to the government have not yielded the results because the ordinance has come. So we probably have to move to the high courts, and another 2-3 months by the time vacations are over, all the files have to move from IPAB to the respective high courts, and then we have to start getting notices from the high court and start dealing with those appeals which are before the Intellectual Property Appellate Board. Let's hope as practitioners in IP, we quickly get these things revived and start arguing our matters before the IPAB and proceed further, and hope that we will have better times to come. Thank you very much. Thank you.
Thank you, Mr. Partha. Like you rightly said, two issues would have been like what you have said, like the IT-80, etc., wherein the retirement age is 62 years, rather than curtailing of 60 up to 65, what you said.
Yeah.
Normally, there are one judicial member and one technical member. Normally, one is retired. So it's very rare that they both are there. Now, another point which has come during these COVID-19 I've experienced is that there is a central administrative tribunal. Now, what happens is one member is in Bangalore and one is in Chandigarh. So they can connect and they make that bench. So that's positive which has come out during these COVID-19 situations where we have done with the virtual courts.
Yeah.
Number two, if we examine or we say what has been held in the Madras Bar Association coupled with Roger Matthews, it says at least these members should have a term of at least of 6 to 8 years as such, so that there is more security.
Yeah, now they have 4 years only. The present amendment, which makes the ordinance, makes it 4 years, which was what was not agreed to do by Supreme Court, but they have reiterated that in the ordinance again is 4 years. So that's again.
I had also challenged the AFT part, wherein they said that the member would be from the same finance from the finance bill, armed from the defense. And similarly, if we examine all this, I will just give TMFI had said that create education tribunals. We have an experience in Punjab. They have a judicial member and a technical member. Again, for a good amount of time, I've seen that there are no members as such. In Haryana, they have given this powers to the district judges.
Okay.
So one aspect could be that these tribunals, at first brush, they could have been given the powers of the, like what happened in this All India Judges Association. They said that you keep on creating posts around 10% higher than what was in the previous year. So there are sufficient number of additional district judges, etc. It's just a loud thought coming off my personal. It could be delegated to such, and then it becomes an appellate, and at least somebody could examine. And like what you said, the technical aspects, these aspects of the tribunals, is always to create a technical member, because the technicalities, let's assume it's an armed force tribunal, central administrative, the bureaucrat, they could understand the nuances of that particular profession, or like a specialization in that particular field. That thought process, yes, there are certain gray areas which can be looked upon. I can see as to whether we have questions, because primarily we have.
I'll just want to say some of them have asked a question whether would High Court have technically qualified members? No, because High Court judges can only be judges. They cannot have, but at least under the Patents Act, they can have appoint technical experts to assist them. But then generally we go for those things only in infringement suits. As you all know, both sides will have their own expert evidence, which will be examined, cross-examined, and then the judge will decide. But a rejection of a patent, and for that appointing a technical expert and then he giving the opinion and then how far that's all going to be possible, both the feasibility of appointing somebody, of course there is a list of technical members from there, whether they want to have experts, and then deciding the issue, because we are talking about rejections of the grant of the patent itself, or an oppositions or a revocation of the patent, where there will be significant numbers, how the High Court is going to exercise the power by appointing the technical experts, but they cannot obviously have technically qualified members. And another question asked is whether technical members have a legal qualification, technical qualification. Generally, the rule prescribed in IPAB was you must have a master's in science or a degree in engineering. That is what is required. And of course, your general, any exposure to patent, etc. is good, and industry experts fine. But the minimum qualification is a post-graduate in science or a graduate in engineering. So that was no requirement that you must have a legal qualification. If you have legal, yes, well and good. But that is the qualification prescribed under the Intellectual Property Appellate Board recruitment rules for patents. Yeah. In fact, on trademark, the technical member is really an advocate who has been practicing in the trademark area. So that is the only place where the advocate himself is the technical member. But in the patents, plant variety protection, etc., you have very specific qualification required of members to become a technical member. I think that's the thing. Yeah.
Yeah.
Those are the two questions I see in the chat box. Yeah.
Because it's a very niche area and more specific, and a lot of thought process you have already evolved with your PPTs, etc. We will request you to share the PPT. We can share it on the group. We have received the notes given by Mr. Uday. We will be sharing on our WhatsApp group. Okay. And those who are connecting us for the first time, they can share, like, and subscribe our YouTube channel, Facebook, as well as Instagram to have the latest updates and where this all sessions are uploaded. So on Tuesday, we will be having a session as the top. Our group name is Beyond Law CLC. We talk sometimes beyond law as such. So we have called Dr. Bharat Chandra, a renowned name on wealth management, etc. So he will be giving us creating wealth for professionals. That is how to manage and invest beyond your professional income so that you have a secured, as they say, pension, aaj bhi aur kal bhi. So on Tuesday, connect with us at 5 p.m. And we have amongst us Mr. Baswara. I will ask him to unmute. He's a Dutch legal knowledge partners with us to propose a vote of thanks. And I'm sharing the mobile number, what they wanted, though I've posted in the group itself for the latest updates. And it's also given on our creative invite. Yeah, Mr. Baswara.
Thank you, Vikas ji. Due to some technical reasons, I become incognito and invisible. Thanks, Sri R. Parthasarathy, for the exhaustive enumeration on the subject. Tribunal Reforms Ordinance 2021 implications. I personally feel that it's a case of one extreme leading to the another. Only time will tell whether the new system would emerge as a good successor to the existing one, or it will fail and again we will go back to the tribunalization scenario. Thanks for the wonderful speech, sir. And thanks, Mr. Vikas ji, for taking this initiative and spreading knowledge across the country by involving eminent scholars and retired judges of the High Court and Supreme Court of India. So thank you.